The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's an honour to rise today on the traditional territory of the Algonquin Nation, and I again say miigwech for enormous hospitality and patience. We are debating today a very important bill, and it's been for us before. It was before us before with its previous title as a private member's bill, C-337, in the previous Parliament. Of course, that bill died on the order paper, but not for lack of support in this place. It was in the other place that it got bogged down for 3 years. The original author of this bill as a private member's bill, and I can say her name out loud because she's no longer here with us in Parliament, was of course Rona Ambrose, who played many distinguished roles in the cabinet of the previous Conservative government, and ultimately, when she brought this bill forward, was interim leader of the Conservative Party. I think it was actually Rona herself who said the problem in the other place was a bunch of old white boys. That's kind of the problem with the people on the bench, too. We have a significant problem that the cultural demographic most likely to sit in judgment in sexual assault cases is exactly the demographic least likely to understand the issues. Most likely, and one must never slur old white men, I sometimes say with tongue in cheek, but I just married one, so I really have nothing against old white men. I love one in particular a tremendous amount, but he'd be the first to say his generation, that group, that privilege that comes from two things: being male, being white, and being presumed to be somebody really special. Well, most judges are fantastic human beings. I mentioned my husband, John Kidder. His grandfather was the Chief Justice of the Supreme Court of British Columbia. So he certainly would not have said anything other than wonderful things about his own grandfather. But I used to practice law. And you always knew if you were taking a case to court, you had to hope you get a good judge. I got a really awful judge once. I have to tell you, I wasn't even called to the bar yet when I went to court both as plaintiff and lawyer with a group of Cape Bretoners trying to stop the aerial spraying of Agent Orange on all of us. This was in 1982. The government of the day had approved aerial spraying with Agent Orange over Nova Scotians. We managed to fight it enough that they changed it to spraying from the ground, and then we went to court. It was a class action. My family lost all of our land, and in a bill of costs to Scott Paper. It was a very ugly case, and in the end, after a 1-year-long trial, well, one from beginning to end, but the actual court case, we were in court before the Supreme Court of Nova Scotia for a full month, making the case that Agent Orange had caused damaged birth defects, cancer in Vietnam. It had been found in groundwater. It was a long, complicated case, but the judge we had, it was his first big case, ruled that Agent Orange was safe and that we were actually bad people for having bothered the Nova Scotia government with our complaints. Now, I mention that because the very next big case this judge got was a sexual assault case. And once again, his words made headlines because he did find the assailant guilty of sexual assault. But the penalty was basically a slap on the wrist because he said from the bench this was not a particularly violent rape. So the assailant found guilty of rape wasn't really punishable because he had not used a lot of violence. I just went through searching for the name of that case. I mean, we know the name of the judge has been referenced frequently in debate today, who said to the victim, why could you not keep your knees together? That the victim's attempts to fight off her assailant had been feeble, and therefore the judge chose not to believe the victim, and the assailant was initially acquitted. That case was in 2016, and our ability to find things through search engines is pretty good for recent history. So that was Judge Robin Camp. It was a Calgary case, and I think there's no stretch to know that that led quite directly to the Honourable Rona Ambrose bringing it forward as a private member's bill that judges needed training. So the case I referenced of it wasn't a particularly violent rape. I'm sure if I could get to a law library, I know I'd find it because it's in the Nova Scotia reported cases from around, I think, 1984. The judge, of course, when I go to search, I discovered that he passed away just in May of this year. So there are nothing but laudatory obituaries for the sterling character of the judge who found that Agent Orange was safe and that the victim in this matter didn't really deserve justice because the rape hadn't been sufficiently violent. I won't mention his name out of respect for the dead. But there are judges out there who need more than training. And we need this piece of legislation to pass. Now, we know that there is more at stake here to get justice for women who experience sexual violence. We know that there are recommendations after recommendations that are critical and that have not yet had any government response officially in the inquiry on missing and murdered Indigenous women and girls. That report says specifically that when an Indigenous woman has been the victim of sexual violence, she must have access to culturally appropriate, sensitive, physical help, support, psychological support, help with retaining the evidence, help from a health professional who is Indigenous herself, who can help a victim and get justice and get through the next stage, which of course is, what do police do? We know there's been, the minister herself, the Minister for Status of Women, made the case just moments ago that quite often it's the police who say, well, we don't find sufficient evidence here. So that notion of unfounded, the pile of cases, I mean, we know that very few women who are sexually assaulted actually report the assault. Then within that group, a great number of people aren't actually believed. Their case piles up in the unfounded category. When it finally gets to court, you need to know the judge understands enough about sexual assault to know that believing something silly like, well, I guess if I was a victim of rape, I wouldn't have been quiet about it so long. Oh, really? What do you really know about it? You need education. So this bill is urgently needed. There's widespread support. As mentioned, it passed this place very quickly when it was first brought forward in 2017 and then got stuck in the other place and then died on the order paper of prorogation. I commend the government for bringing it back as a government bill. Obviously, it will be much more quickly passed as a government bill than if we were to wait to see who brought it forward as a private member's bill. I also appreciate the changes that were made that expand the notion of education for judges from questions of sexual assault law to include something which in C3 is referred to as the social context. And I know that there are many members of this place who'd like to see social context further amended to make it clear that we're talking about things like systemic racism, intersectionality, poverty, assumptions that are made about sex trade workers, assumptions that are made about the marginalized, assumptions that are inherently discriminatory towards women. So in looking at the social context piece, I know there will be some desire to amend the bill to bring it into a fuller understanding that we could actually use this legislation to deal with issues with which we are now far more seized. Questions of, for example, systemic racism in police forces, systemic racism within on the benches of our courts. We could maybe deal with more issues with amendments. So in order to make sure I don't run out of time, Mr. Speaker, I want to turn to what I hope will be acceptable to all members in this place, and that is a proposed motion that I hope that if you seek it, you will find unanimous consent to speed up this bill, to help us get it to committee faster and skip the second reading stage. That's my intent here. This is how it would read. Mr. Speaker, that notwithstanding any standing order or usual practice of the House, at the conclusion of government orders today, or when no member rises in debate, whichever is earlier, the Speaker shall forthwith put and successfully all questions necessary to dispose of the second reading stage of Bill C3 and act to amend the Judges Act and the Criminal Code, provided that if a recorded division is requested, it shall be deferred until Monday, October 5th, 2020, at the expiry of the time provided for oral questions. I hope this motion's in its proper form. The clerks have it. I apologize to friends on the other side of the House because normally I would run around and speak to each of you personally. I relied on getting it to you electronically. I hope, Mr. Speaker, that if you seek it, you will find unanimous consent to move C3 immediately to committee stage and skip second reading with a possibility for a vote on Monday should other parties require it. Thank you. Thank you, Mr. Speaker. Thank you, colleagues.
Does the honourable member for Saanich Gulf Highlands have the unanimous consent of the House to propose this motion? Do I hear any noes? No. Okay, there is no consent. We'll now go to the honourable member for Cowichan-Malahat-Langford on a point of order.
Yes, Mr. Speaker. It's just following up on the motion that the member for Saanich Gulf Islands brought up. I just really hope that all parties can find a way to reach agreement on Monday and get this bill to committee. Please, we need to get the committee work started on this bill.
I think that's probably not in the point of order column there, but it's okay. We'll now go to questions and comments. Questions et commentaires? I have one. Oui. Par conférence virtuelle.
Through video conference, the honourable member for Trois-Rivières. Mr. Speaker, I would like to ask and thank my honourable colleague for her speech. I'd like to know if she thinks that in this situation, do we give enough credibility to women who are raped? And is this credibility in the story that the minister presented? The police decide whether to give this credibility to what statements that women make. Is it enough to wait till things are before the judges? Thank you very much, Mr. Speaker.
Member for Saanich Gulf Islands.
Merci, Monsieur le Président.
Thank you very much, Mr. Speaker. And I'd like to thank my colleague, the member for Trois-Rivières. If I understand her question correctly, it's a question of credibility of women who are victims, particularly for women who work. This group has the same rights like all other women to protect their own identity and bodies against violence and against sexual assault. Sexual assault, yes. So I think it's also a question in terms of education and training for everyone, for the police, for judges, for lawyers, for everyone, and particularly men in our society. There are also our colleagues in this, and it's up to them. You don't have to be a woman to be a feminist. There are men as well who are very in favor of women's rights. But I think we do realize that there are men who do not believe victims, particularly if they work inaudible.
Questions and comments? Member for Dorval, Lachine, LaSalle.
Me and giving me some time to ask a question. I always listen with great fascination to my colleague from the Green Party. She always presents with compassion and with the utmost consideration of all factors involved. I would like to ask her two questions. One, if she thinks that more females need to be in the judiciary and more females of diverse backgrounds, as she spoke about Indigenous culture being part of the justice system. And when it comes time to make decisions, when it comes time to listen to these victims, that there has to be cultural sensitivity. And is there not an appalling lack of females and ethnically, religiously, whatever, people of color, diversity on the bench? And would this help in such cases? The second question is, can she please speak a bit more as to the urgency of why we should go only with a first reading? Thank you so very much. Thank you.
Honourable member for Saanich Gulf Islands.
I thank my dear colleague. If it wasn't for COVID, we would be sitting closer because our assigned seats allow me to have frequent conversation with the member for Dorval-Lachine-LaSalle. I would absolutely agree that the demographics of the bench are pale, male, and stale. It's just what it is. So that's a question for, and it's a hard one because, I mean, when I became a lawyer in 1983, when I started law school, 1/3 of the class was women, and that was a big change. And some of my friends, like Ann Derrick, is a trailblazing lawyer, an activist lawyer, who's now sitting on the bench in the Nova Scotia Supreme Court. And she's fantastic, right? So there are changes happening, but the diversity around ethnicity, the diversity around religious, cultural backgrounds, Indigenous lawyers and judges are desperately needed, as are Indigenous-led police forces that have the trust of a community because they have the community's back. And to the second question of my honourable colleague, we need to get this bill through speedily. There have been far too many delays in the last Parliament, and I hope that we can find all parties a way to advance this bill without having to repeat all the steps that we did in the last Parliament to have the unanimous support that this bill enjoyed.
Resuming debate, and before we go to the honourable